Welcome to freedivorce.com.
This is Christina.
And this is Ed. Today we're going to talk about reimbursement claims. There are numerous types of reimbursement claims that a party can make during a divorce, and in this video we're going to discuss some of the more common reimbursement claims. So Christina, would you please explain what is a Family Code Section 2640 reimbursement claim?
If you or your spouse used separate property during the marriage to purchase a community property asset or to improve a community property asset, then there may be a valid reimbursement claim under the provisions of California Family Code Section 2640. We gave a couple of examples of this type of reimbursement claim in a prior video that covered the division of the family residence, where one party used pre-marriage savings for a down payment on the family home, or where one party used inherited money to pay for the construction of a swimming pool for the family home. When one party uses their separate property to do any of the following, there can be a reimbursement claim. Number 1, purchase a community property asset, including making a down payment. Number 2, paying for an improvement to a community property asset. Or 3, reducing the principal of a loan that was used to purchase or improve a community property asset.
Okay, so let's say the mortgage payments on the family home are $4,000 per month, and I use my separate property funds to pay the mortgage payments. If my wife and I later get a divorce, will I get a $4,000 credit for each mortgage payment that I made?
No. Your reimbursement claim is limited to the amount that the loan principal is paid down. You don't get any reimbursement for payment of the interest portion of the mortgage, which is typically the bulk of the payment. If your mortgage payment includes impounds for property taxes or homeowners insurance premiums, you don't have a reimbursement claim for payment of property taxes or insurance, just payment of principal. So if you use your separate property funds to pay monthly mortgage payments, you can get reimbursed for that part of the payments that reduce the loan balance, but not the portion that went to the mortgage interest, taxes, or insurance.
Okay, so what if I use my separate property funds for a down payment on a house years ago, and the house has appreciated over the years? Do I get any interest on my down payment, or do I get any part of that appreciation?
No, the amount of reimbursement is without interest and without adjustment for changes in monetary values. For example, assume you owned a home before marriage. During the marriage, you sold your home and netted $200,000. You used the $200,000 for the down payment for the purchase of the family home that cost $500,000. You and your spouse took title to the family home in both of your names as community property. During the marriage, the family home appreciated over a period of years. At the time of the divorce, the home is worth $1 million. Your reimbursement claim is limited to the original $200,000 amount that you put in.
So even though we took title to the new house as community property, I still have a right to be reimbursed for my separate property down payment? Is that correct?
That's correct. It doesn't matter that you took title to the family home in both names as community property. You still retain your right of reimbursement for that down payment.
All right, what if I use my separate property funds to make improvements to my wife's separate property? For example, let's say my wife comes into the marriage already owning a house, so that's her separate property, and during the marriage, I use my separate property funds to make improvements to my wife's separate property house. Do I still have a right of reimbursement?
Yes, Family Code Section 2640 also provides for a right of reimbursement if one party uses their separate property to acquire or improve the other party's separate property.
If I'm going to make a Family Code Section 2640 reimbursement claim, do I have to prove that the money which was used was actually my separate property funds?
Yes. Oftentimes, when a party raises a Family Code Section 2640 reimbursement claim, there's going to be a problem with tracing the claim. If you claim you used your separate property funds to acquire or improve a community asset, the burden of proof is on you to produce evidence that traces the use of the separate property to the purchase or improvement of the community asset. If you can't produce the tracing evidence, which typically involves producing documents such as bank records or escrow closing statements, then you will likely lose your reimbursement claim. It is not uncommon to lose a reimbursement claim because the documents you need to trace the use of your separate property funds can't be located or no longer exists. Ed, would you please explain what Epstein credits are?
Sure. After you and your spouse separate, one or both of you may use your separate property funds, such as your post-separation earnings, to pay all or part of community debts. If so, a reimbursement claim for Epstein credits can be made. So, for example, one party may make payments on community credit card debts after you separate, but before your case settles or before your case gets to trial. Even though you and your wife or spouse are going through a divorce, creditors still need to be paid. One or both parties are going to have to step up and make payments to creditors while you're waiting for a divorce settlement or waiting to get to trial. The party that pays the bills will be entitled to Epstein credits.
Do Epstein credits only apply to credit card payments?
No, Epstein credits can apply to all types of post-separation payments made on community obligations, including, but not limited to, payments on credit cards, payment of income tax liabilities, car payments, mortgage payments, home equity line of credits. If it's a community obligation and you make a payment after you separate with your post-separation earnings, you're going to get an Epstein credit.
What if one spouse pays all the bills after the parties separate because the other spouse and the children need support?
Well, that's a different situation. If payments were made in lieu of support payments, meaning in place of support payments, then the court may deny all or part of the Epstein credits. As an example, let's assume a couple separates. Wife and the minor children stay in the family home, and wife does not immediately go to court and seek a child support or a spousal support order. And what husband does is he uses his post-separation earnings to pay the monthly mortgage payments on the house where wife and the kids are staying, and he uses his post-separation earnings to make car payments and to pay other various bills on behalf of wife and the children. But he does not pay any support money directly to wife. If, during the divorce trial, husband comes in and claims Epstein credits for making these payments, the court will probably deny his claim on the grounds that the payments he made were made in lieu of support payments.
If I use my separate property funds, such as my post-separation earnings, to pay community bills, is there anything I should be doing to make sure I get the Epstein credits?
Yes. If you use your separate funds to pay community debts after you and your spouse separate, it is very important to document your payments. Go get a binder, and every time you make a payment on a community debt, make a copy of the bill. And every time you make a payment, make a copy of the check you used to make the payment. Put those copies in the binder. You're going to need those documents to prove your Epstein claims later on when you get to trial. All right, Christina, would you please explain what Watts charges are?
Sure. After you and your spouse separate, one party may make use of a community property asset, and the use of that asset may have a significant rental value. For example, assume the family home is paid off, and the home has a rental value of $4,000 per month. Assume one spouse occupied the family home for a year at essentially no cost before the case goes to trial, while the other spouse rented a similar home and paid $4,000 per month in rent. The first spouse would be subject to a Watts charge in the amount of $4,000 per month for the fair rental value of the family home. The first spouse would owe the community $4,000 per month for the 1-year period. If the family home had a mortgage that was $1,000 per month, and the party who stayed in the home paid that $1,000 for 1 year, then that cost, which is like an Epstein credit, would be offset against the fair rental value for a net Watts charge of $3,000 per month. The Watts charge is owed to the community, not the other spouse, which means the other spouse receives only 1/2 the amount of the Watts charge.
Do Watts charges only apply to the use of the family home?
Watts charges can apply to the use of any community asset that has a significant rental value. The concept of Watts charges could apply to one party's post-separation use of a car. For example, if one party makes use of a community property car that is paid off after the date of separation, while the other party uses a community property car that has a large monthly car payment, then Watts charges may apply.
If Watts charges are determined by the fair rental value of an asset, what if my spouse and I can't agree on the amount of the fair rental value?
Oftentimes, when you're dealing with Watts charges, there's going to be a dispute about the amount of the fair rental value of the particular community asset involved. You may need a realtor to provide evidence about the fair rental value of the family residence.
Do I need to give my spouse any warning that I intend to seek Watts charges?
Some courts have local rules regarding Watts charges that require you to give written notice to the other party of your intent to seek Watts charges, so the other party is not surprised at the time of trial. If you intend to assert a Watts charge against the other party, send the other party written notice of your intent early on in the divorce process.
There are many other types of reimbursement claims that we did not cover in this video. For example, in the video we did on student loans, we talked about reimbursement claims that can be made when community funds are used to pay for all or part of one party's education or training. Another reimbursement claim that we really didn't discuss comes up when community funds are used to pay one party's separate debts. A discussion of all the different types of reimbursement claims available in a divorce is beyond the scope of this video presentation. What we've tried to do is to go over the most common types of reimbursement claims. This has been a presentation by freedivorce.com.